Hello, we're going to briefly have a look at the American legal system and how that impacts upon healthcare leaders. And so let's jump into it. Our agenda this evening is, or today, depending on what time you're looking at it, is the U.S. legal system, or the federal legal system, and the state legal system. In our case, we'll talk a little bit about the Virginia legal system, but no matter where you may be living or working, the systems are fairly analogous. So bear that in mind. Let's talk a little bit about some important distinctions in the legal system that aren't always intuitive and even sometimes confused by reporters as we see them in the media. The first is criminal law. Criminal law has to do, and criminal courts have to do solely with offenses that are prosecuted by the state. Does not involve personal injury claims. It doesn't involve workers' compensation claims. It doesn't involve divorce or lots of other reasons that people would appear in court. Criminal matters are only brought by either the United States attorney or by the prosecutor in your jurisdiction, which may be referred to as a district attorney or a commonwealth's attorney, or some places they're referred to as state's attorneys. Civil cases are what we usually see in regard to personal injury. All medical malpractice actions are brought in as a civil matter. Civil meaning that it's brought between two citizens. One citizen is prosecuting or seeking some remedy against another citizen in the state or federal courts. Regulatory and administrative matters will be something that as an administrator you're going to have to unfortunately spend a lot of time with. These are all of the enforcement actions that may be brought by CMS, by the Office of the Inspector General, OIG, by the IRS, by OSHA, the Office for Safety Health Administration, and any other of the folks that may be looking from the government, either at the federal or state level, to enforce regulations. And again, these are regulations. It may be that you want to appeal reimbursement levels. That is an administrative action. It's not a civil action. It's not a criminal action. It is brought under the administrative code. And as part of your reading for this section, you're being asked to review the Virginia Administrative Procedures Act, which looks a lot like the Administrative Procedures Act in a lot of other states, as well as with the federal government. And you'll see that the process there is quite different than what it would be in either a civil or a criminal trial matter that may be brought. So how is the legal system divided up? Well, the federal system is divided into what we refer to as circuits. Each state has federal courts that are part of its jurisdiction. If we can look at Virginia, for example, we have two federal districts. We have the Western District, which is Charlottesville, sort of west, all the way out to the Tennessee-Kentucky border. And then we have the Eastern District of Virginia, which is Alexandria, Richmond, and Norfolk. And somewhere in between Richmond and Charlottesville is some magic line that divides the Eastern and Western districts of the U.S. District Courts. The district courts are the level at which trials are held. It is the place where criminals are tried, patent cases are prosecuted, all other matters that may come before a trial court come before the U.S. District Court. An appeal from the U.S. District Court goes to the Fourth Circuit for cases out of Virginia, Maryland, and West Virginia, as well as North Carolina. The appellate courts are divided into circuits, where in the Fourth Circuit, you'll find, for example, that in Illinois, the Seventh Circuit covers that territory. It covers Illinois, Wisconsin, Indiana, Iowa, Missouri. On the West Coast is yet another circuit. I believe it's the Ninth Circuit, which is Mr. Trump's bane, that they like to make short work of his conservative agenda. But the circuit courts, federal circuit courts, will hear all appeals from the trial court. From there, a matter would go to the U.S. Supreme Court, which is the final arbiter of all federal questions in the United States. It is the U.S. Supreme Court operates in a far different fashion than other courts in that it is not an appeal of right. The U.S. Supreme Court determines whether it would like to entertain an appeal or not. And so you'll find that people are filing a petition certiorari. That is, they are pleading with the court to take their case. They take only a few of the hundreds and hundreds of cases that are submitted each year because of a number of reasons. It may be an important legal question. It may be a question that they just find interesting. It may be one that has kind of become a popular issue that needs to be dealt with. And so there is no particular rhyme or reason as to which appeal is taken. It is at the discretion of the justices to determine which cases they would like to have appealed. So with that in mind, we kind of can look down from the law side as to how the U.S. is organized. Obviously, the fundamental document is the U.S. Constitution. In there, you'll find described as one of your reading assignments. You'll find described the office of the president, the legislature, and the courts. That creates the federal judiciary, referred to as Article 3 judges, which are the trial judges, and the appellate courts that hear appeals from them. Federal laws are those that are created by the U.S. Congress, which is composed of the House of Representatives and the Senate. Any laws not or any laws or rights not explicitly reserved to the federal government would be under the aegis of the state legislatures. Federal government, of course, promulgates a ton of regulations that you will see every day in practice of healthcare, as well as being the courts. And one of the things that you will want to keep in mind is that administrative tribunals will deal with a great number of the healthcare issues that confront your institution. For example, if there is an issue as far as federal reimbursement for healthcare, that is an administrative matter. If you are in the crosshairs of being delisted, as we'll talk about later, blacklisted as a provider, that is initially an administrative tribunal issue. If someone is disabled, that is an administrative issue. So administrative tribunals are extremely important in healthcare regulation. So let's then switch to the Virginia legal system, which is very similar, as you might guess, because much of the federal government was modeled on the ideas of the Virginia leaders at the time. And so in the state, we have a constitution that has been rewritten a number of times. We have laws that are created by the General Assembly. And for those of you who may not be native Virginians, Virginia has a fairly unique legislature that meets at most 45 days on their short years, at most 60 days in their long years, and with the idea that the legislators should be citizens, members, and not professional politicians. The state also promulgates regulations. For example, it promulgates regulations related to hospitals, nursing homes, the practice of medicine, nursing, any other of its licensed or certified entities will have regulations that are promulgated by the state. Again, very important that one keeps in mind that regulations can be the end-all and be-all of whether or not you're allowed to practice your profession or run your facility in the Commonwealth or in the state where you're located. Likewise, we have courts in Virginia. The courts in Virginia are consolidated, which is a fairly assumed term these days, but in some states that's not the case. A state court in Virginia can hear all claims, whether they be divorce claims, contract claims, civil claims, all are brought in the same court. They may start at the level of a district court or a juvenile and domestic relations court for those particular matters, but will eventually rise up to the circuit courts. Again, we have administrative tribunals that are very important to the healthcare provider. If you're a physician, the Board of Medicine holds informal conferences and formal conferences that we'll talk about in more detail later. The certificate of need is an important administrative tribunal here in the Commonwealth because it limits whether or not you can get that new expensive toy for your hospital or not. So let's talk about finding law, which is unfortunately a title that has been kind of whited out on this slide. But the we'll talk about primary sources of law. We'll talk about secondary sources of law as we go forward. So let's jump into it. The primary source of laws are, of course, the actual text of the law itself. Some of you may recall the controversy about the Supreme Court justices as to whether they were textualist or literalist. That means that they based all of their decisions on the actual text of the law, not what the justices believe the law ought to be, or what the intent of the law was. Next is, of course, regulations. These are extremely important as to what the regulation actually says. I often tell clients that HIPAA is much like the Bible in that many people quote that they cannot do something because of HIPAA or HIPAA requires them to do something, but very few of them have actually read the regulation. And so it's important that before one starts citing a reference like the regulations, whether that is HIPAA or HITECH or the Universal Safe Practices, one ought to actually have a look at those regulations to see what they have to say. And of course, another primary source are the case decisions by judges on what the regulations and laws actually mean. We have in the English tradition precedent, and so if a case is decided one way, it is encouraged and expected that all subsequent decisions would be made the same way. Predictability is an important part of the American legal system so that we know how to conduct ourselves going forward. Let's talk a little bit about legal research, and I apologize for the titles in these slides. They seem to have somewhat disappeared on us. But we'll talk a little bit about case citations and how you go about reading those. They are actually much easier than what you would guess. We'll also talk a little bit about key number searches, and we'll talk a little bit about shepherdizing. We'll talk about Boolean searches, which is kind of the way that we all search Google these days, and we'll talk a little bit about secondary sources. So let's talk about what the case citation is. If you look at a traditional Supreme Court reporter, which is interesting because I actually had to go to the Virginia Law Library to find one. Our law firm, and like most law firms, does not have a traditional law library, and it does not have the shelves and shelves of case decisions like we once had. Those are best found these days at used bookstores. But anyway, looking at how we decipher a case decision, here is the number of the volume. And in this case, it is 93. It is the 93rd volume of the U.S. Supreme Court Reporter, and it also contains within it, in a dual or parallel sort of citation, volumes 409 through 411 of the U.S. Reporter. All you need to know pretty much for this process is that this is the 93rd volume of the Supreme Court Reporter. With that in mind, when we open the book up, we'll find that for the case that you are reading, Roe versus Wade, it is found here. And the citation is the 93rd volume of the Supreme Court Reporter at page 705. And right here is our page number. And so you'll see cited from time to time 93 Supreme Court 705. That is the traditional way that we as lawyers would go about finding cases and looking them up, is that we'd go to the stacks and we would find the 93rd volume of the Supreme Court Reporter and turn to page 705. Obviously, for anyone born in this century, or even close to this century, that's not the way we do it anymore. It is almost all computer searching now, but we can still search by those citations. And so let's look at Roe versus Wade. And let me back up. Well, we'll jump right into it. The case citation is how we would find them. Key number searches were created by West Publishing, and within cases you will find that there are numbers, and that was a traditional way that we would go about searching for, if we were looking for privacy, and we would look for the citation number or the key number, which was another way of trying to index all the decisions on that topic. And now, of course, we can do that all electronically within a matter of seconds. It used to be that it employed young lawyers for days and days tracking all that stuff down. Shepardizing is a term that you will use, again, a bit archaic, but that is a means by which all of the prior cases or subsequent cases can be found. If you are looking at Roe versus Wade and you want to know, well, what cases have been decided based on Roe versus Wade since then, you would do what was referred to as shepardizing. In the old days, that was a number of textbooks that had all of the citations, and you would have to go down a list and find your case and see who had it been cited by. And every month to 6 months to a year, a new book would come out that would list all of the new citations of the year of Roe versus Wade. Again, thank God it's all done electronically these days. Boolean searches you may be familiar with from other IT situations. Boolean searches are simply using keywords to search by. If you are interested in finding Roe versus Wade, you would simply type in Roe Wade, and you would probably find this case decision. You can do that in the law databases these days as well. You can put in right to abortion or abortion privacy. Any of the key words that you may find important, you can simply type those in. Secondary sources in legal research are those that talk about the law or interpret the law. That may be guidance from an agency. Guidance from an agency, even if it's Medicare, Medicaid, or from a state agency, is simply that, guidance. In order to be a regulation, it has to go through the process of being made a rule or a regulation. Sometimes I have found myself differing with administrators in state agencies when they cite their guidance as the gospel. It has not been verified as gospel yet. It is simply guidance, and so therefore one cannot be held responsible or sanctioned for not following guidance when it's not actually the regulation, and that can be important in some cases. So let's talk a little bit about guidance. One example I had was years ago, I had a hospital I was representing. They had an event happen in the hospital, and the state agency came down on the hospital for the fact they hadn't reported this incident. And the basis for their point was that all serious injuries had to be reported to the state agency. I pointed out to the surveyors that in fact there had been no serious injury as defined by the statute, which was loss of life, limb, lots of blood, that sort of thing. And the surveyor came back and said, well, yes, but in our guidance, we also say that serious injury is any matter that might draw significant media attention. And I pushed back that, in fact, that was simply guidance. And in the future, we might keep that in mind, but we could not be sanctioned for having not reported an incident that did not involve actual serious injury. And I was able to persuade them to back down. Other guidance that is important, or other secondary sources that are important, may be what's referred to as law review articles. These are written usually by academics, either professors or students, sometimes practitioners, but not so much, that interpret law, argue how the law should be developing or where it should go. And these can be relied upon by courts as persuasive, but they do not, again, bear the stamp of legitimacy that a law or a regulation has, and can't certainly provide the basis for one being sanctioned. There are lots of other secondary sources out there these days, as you might guess. There are lots of people who blog. without any sort of peer review, and law review articles are usually peer reviewed. Blogs are simply whatever you want to put on the web, you can have a go at it. And so one has to be careful as to how strong and solid foundation those blogs may have. I mentioned earlier in the prior video that we are said to be the second most regulated industry. Excuse me, I would argue that we are in fact the most regulated industry, that we are second to none these days, and it's only going to get better for us, as our population continues to mature, so too will the standards and expectations that are expected of us, and that often translates into more regulations, more efforts to force practitioners to do the right thing, when in fact it makes getting to the point of doing anything sometimes impossible. One of the important things for you to keep in mind is that many of these laws and regulations are not necessarily intuitive. We'll talk about the fraud and abuse, the Stark regulations. All of those are purely creations of legislators' minds that quite differ from certainly the entrepreneurs and even the sense of fair play at times. So it is important to be conscious of what the regulations actually are and not simply going with one's gut instinct. We are the popular villain. There is apparently millions and millions of dollars in money sloshing around in healthcare that is being stolen and used improperly by us who practice the art. I would suggest that we are kind of the victim of expectations, that because of the expectation that we may have been part of creating of how wonderful our outcomes are and how efficient we are, that we are the ones that are easy to be the bad boys when you see someone cross the lines and are indicted for having embezzled lots of money, or that are driving Lamborghinis and raising the prices of drugs and those sorts of things that are certainly not popular amongst folks who aren't in healthcare. Why is this important to you? Well, compliance is a big issue in healthcare these days. The expectation of the federal government is, and even the state government, is that you will have a proactive plan in place to assure that all of your employees are aware of what the current regulations are and will do their best to comply with them going forward. Certainly litigation is another matter that's going to be high on the agenda of anyone in administration of healthcare these days, whether that is medical malpractice, whether it may be antitrust, it may be intellectual property. All of those things are part of doing business in the healthcare arena. Certainly criminal issues pop up from time to time. Much of what we see in the fraud and abuse category these days is in the criminal context, whether that is because you are improperly advertising drugs, whether you are improperly billing for your services. Any of those things can lead to you being in a civil, or I'm sorry, in a criminal situation. And last but not least, of course, is exclusion. If you are found to have crossed the line, whether that be in violating federal regulations or in criminal matter, you can be excluded from any of the federal healthcare programs. And that exclusion is pretty much the kiss of death, because you can't really operate much of a healthcare system in the United States without federal dollars flowing into it. And you cannot hire anybody who has been excluded. So if you want to be a leader in healthcare, you don't want to be on the exclusion list. With that in mind, that brings us mercifully to the end of this presentation. We'll be jumping into medical ethics next, and I appreciate your patience. Look forward to your exam results on this section, so make sure that you take that in a timely fashion.